As they say that one who joins law is always a student of law. We've also seen that the victimology concept has evolved recently, and thereafter, what are the subtle changes which have been brought forth in BNS is the interplay of concept of victimology and BNSS, is what Mr. M.Karunanithi, an advocate, member Law Commission of India, special public prosecutor for CBI in cases in High Court, and a senior panel counsel for Union of India, would be sharing his knowledge. We have seen that because of his vast knowledge, he was added as a member of the Law Commission, which itself shows that his knowledge is even well recognized within the relevant corners. And the factum that his knowledge for evidence is also apparent, that if we see back at his library, law of evidence is reflecting, the books are being reflected in the library as clear as the noonday. Without taking much time, I will ask Mr. Karunanithi to share his knowledge. Over to you.
Namaste to one and all. My sincere thanks to the organizers and the learned friends joined here. Today, I am going to discuss on the topic of Victimology and BNSS 2023. My learned friends, you all know well, very recently, since 1/7/2024, Bharat has got 3 new criminal laws. Bharatiya Nagarik Suraksha Sanhita 2023 replaced the Code of Criminal Procedure 1973. No doubt, the penal provisions has been inserted as a measure of victimology to give justice to the victim. Whether it is sufficient enough, whether there are provisions enabling the victim or the first informant or the legal heirs to pursue their own case or to assist the public prosecutors, whether the law as on today are sufficient enough to say the victims have been protected. That warrant me to choose this subject. The Code of Criminal Procedure 1973, when CRPC 1973 has been brought into force since 1974, even the term victim has not been defined. The term victim has not been defined at all. My brothers and sisters may raise a question or may ask me, sir, though not defined, what is the difficulty? Whether the provisions available under the CRPC are not sufficient enough to safeguard the rights of the victim. Yes, there are some provisions, but to my view, it is not sufficient to protect the interest of the victim. They very recently, by Act 5 of 2009, with effect from 31/12/2009, the term victim has been introduced in the definition class section 2WA in the Code of Criminal Procedure 1973, and in BNSS 2023 also the term victim has been defined well. Victimology is the scientific study of victimization. There is no law in India specifically supporting theory of victimology. In many countries across the world, the victimology has been approved and codified. Though there is no specific law in India approved the victimology, the same has been developed by the higher judiciary, that is by the Honorable High Courts across the country, as well by the Honorable Supreme Court of India. There are a curtain of decisions, and those decisions has been codified as provisions in the BNSS 2023. So we are thankful to the lawmaker to bring BNSS and BSA 2023. No doubt, only to render justice to the victim, penal provisions has been enacted. The learned counsel appointed by the victim cannot conduct the prosecution. They cannot address orally, even they cannot argue the case, they can submit their written arguments. Only in the prosecution taken out under the provisions of SC/ST Act, the victim can be permitted to appoint special public prosecutor as per their own choice. Whether there are any difficulties to that effect, to my view, according to me, no doubt all the crimes are committed as against the state, and it is a duty of the king, the ruler, to protect every citizen from crimes, no doubt at all. But still, the victim of a crime has to be permitted to conduct, at least to argue their case by their counsel. I want to point out a case decided by the Honorable Madras High Court, a famous case, P. Alagarsamy versus State of Tamil Nadu. P. Alagarsamy versus State of Tamil Nadu. This is a case decided by the Principal Seat of Madras High Court. This is a case arising out of SC/ST Act. The FIR was registered under Section 3110 of SC/ST Act. Final report was filed by the Inspector of Police. Cognizance was taken by the learned magistrate for the offence under Section 341 and 323 of IPC. And accused filed an application admitting their guilt. Sentence of fine was imposed. Now the importance of the judgment is the said conviction was challenged before the Honorable High Court under Section 482 of Code of Criminal Procedure 1973. No doubt, if there is a conviction, the conviction can be challenged by way of an appeal. If there is no adequate sentence, still the de facto complainant can move the Honorable High Court by way of a revision under Section 397, read with 401 of CRPC. This is a peculiar case. An application under Section 482 of CRPC was moved before the Honorable Madras High Court to secure the ends of justice. No doubt, any order can be passed by the Honorable High Court by exercising the powers conferred under Section 482 CRPC. No doubt, Section 482 of CRPC 1973 does not confer any power. It is only a savings clause. By the very Constitution, as a High Court, the Honorable High Court has got every power to pass the order to prevent the abuse of power and to secure the ends of justice. No doubt at all. This is a case, this point was raised. Since the investigation as per Rule 7 of SC/ST Act, the case has to be investigated only by the officer not below the rank of Deputy Superintendent of Police. Since the case under challenge before the High Court was investigated by the Inspector of Police, the conviction was quashed. I think this is the first judgment. The conviction was quashed by the Honorable High Court and re-investigation was ordered. And re-investigation was ordered by the Honorable Madras High Court. Yet another judgment decided by the Madurai bench of Madras High Court when I appeared. Maulana versus State. In the FIR, some offences tribal by court of session was there. Conviction was, final report was filed for the offence under section for the minor offences, thereby omitting the major offences by the IO. The learned magistrate was pleased to take cognizance. Ignoring the principles rendered by the Honorable Apex Court in Bhagwan Singh case, the learned magistrate was pleased to take cognizance. The order taking cognizance was challenged before the Madurai bench of Madras High Court. The same was set aside. Cognizance taken by the learned magistrate was set aside in MJM Maulana versus Inspector of Police, Armuganeri Police Station and others. The prosecuting agency was directed to further investigate and to file final. So, there are no provision. If A is preferring complaint before the police, giving information regarding the crime, except the giving report to the police, he has no role at all to play. In the scheme of investigation, the first informant has no role except to giving first information. He has no idea. He cannot be any role or any idea to know about the progress in the investigation. The investigating officer is not by rule of law has to inform about the investigation to the first informant or victim. Even the learned magistrate need not give a notice to the victim or the first informant when negative final report or partial negative final report is filed before the learned magistrate before taking cognizance. I have already stated, though the victim protection scheme and other provisions have been enacted in other countries, the rights of the victim have been protected by the Honorable Apex Court and Madras High Court in many cases. In Bhagwan Singh case, there was a direction given by the Honorable Apex Court before taking cognizance, before accepting the negative final report, though there is no provision compelling the learned magistrate to send a notice to the first informant or victim. By the judgment made in the Bhagwan Singh case, notice is to be issued. In the same line, in the Madras High Court, there is a rule framed in Criminal Rules of Practice 2019. Thereafter, in yet another case, namely V. Koil Pillai versus State of Tamil Nadu, by its Secretary, Home Department, Chennai and others. This is also a very peculiar case. This is after the acquittal made in a murder case. Acquittal was recorded by the learned session judge. There was an application under 482 CRPC before the Honorable Madurai bench of Madras High Court. Roving inquiry was conducted by the Madurai bench of Madras High Court. The deceased, said to be the deceased in the murder case, appeared before the Madurai bench. DNA test was conducted, and finally, the Honorable Madras High Court set aside the final report and all other consequential proceedings, including the order of taking cognizance. There was a positive finding that the so-called deceased was alive, and a compensation of rupees 4 lakhs was awarded to each of the accused. No doubt, victim at the hands of private individual, as well as victim by the hands of public servants. We can take victim at the hands of the police officers. The individual can move the Honorable High Court under Article 226 of the Constitution of India, or under by invoking the inherent jurisdiction of the High Court to rectify the same. Whether any special provisions has been enacted in the BNSS 2023 supporting the victimology, my answer would be the entire scheme of 3 criminal laws is a victim-centric laws. The definition of victim is very much available, and the investigation officer has to inform the victim or the first informant about the progress made in the investigation. Appointment of any person in the absence of assistant public prosecutor by the district magistrate by invoking power under section 19(3) by giving 14 days notice to the state government. District magistrate has been conferred power in case of there is no assistant public prosecutor to prosecute the case before the learned magistrate. The district magistrate can appoint. This is yet another important development in the criminal procedure, because before the learned magistrate court, criminal prosecution has to be conducted only by the assistant public prosecutor. They have to take care of the prosecution case. If there is no other APPs are available, even before appointing the assistant public prosecutors, there are so many procedures has to be followed. There must be a notification, there must be examination and all other things. So section 19(3) enable the district magistrate to appoint assistant public prosecutors by giving notice of 14 days notice to the state. And section 20 gives comprehensive directorate of prosecution district level. Comprehensive directorate of prosecution in the state level as well in the district level. And witnesses protection program, there is a provision. And accountability has been fixed in section 20 of BNSS, giving opinion. In case of giving opinion, and for the first time, to monitor the prosecution case, to monitor the case, there is a segregation with regard to the sentence. There is a provision. Section 20 speaks about monitoring the prosecution cases. And section 179 subclass 1 BNSS, witnesses aged more than 60 years or ill persons need not attend the police station. And power of the learned magistrate in sentence of fine, that has been increased. That has been increased. Regarding the arrest, to inform about the arrest. As on today, there are many cases before the High Court regarding the illegal arrest. So after the BNSS 2023, in every police station, one ASA has been appointed to inform about the arrest, as well in the district level to notify the arrest. There are provisions. And insofar as medical report, in many cases, the Honorable Judiciary has taken note of delay in conducting the investigation, delay in getting medical reports and forwarding the material documents to the court. Here, medical report to be forwarded to the investigating officer without any delay. And concept of preliminary inquiry has been introduced. And that preliminary inquiry, there are many cases across the country before the Honorable High Court. There will be a complaint before the Superintendent of Police. That complaint will be forwarded to some of the police stations, and they will summon all the persons. They will conduct investigation under the guise of inquiry. They will call all the persons said to have committed the offense. They will not conclude the investigation. They will keep the matter pending for quite long. There are number of cases are before the Honorable Madras High Court as well before the Madurai bench of Madras High Court challenging the inquiry. Now, there is a welcoming provision in section 173 subclass 3. When offences, they are punishable within 3 to 7 years. And absolutely in case of necessity, only with the prior permission of Deputy Superintendent of Police, preliminary inquiry can be conducted, and that has to be completed within 14 days, from the first date of inquiry. So the entire BNSS is in support of victimology. So there are many provisions, namely timeline. The timeline is the very, very important. There is a timeline to conduct the investigation, to complete the preliminary inquiry, to file final report. After filing final report, learned judge has to take cognizance of offences. Thereafter, learned judge has to furnish, as soon as the accused appeared before the learned trial court, copies of the prosecution document has to be furnished to the accused, and the delayed tactics will commence from the furnishing of copies. No doubt, there are many cases not even committed to the court of session for quite long years, even after 10 years. So the BNSS 2023 made a full stop for all the tactics. The copies has to be furnished within a particular period. If it is a case of sessions case, trial by court of session, the copies has to be furnished within a particular period. The next stage is the application for discharge. Application for discharge cannot be filed after quite long time, at any date, after framing of charges. After the first hearing, whether it is a case trial by court of session or trial by learned sessions court, the discharge application can be filed at a particular, and witnesses has to be examined, and trial shall be completed after hearing the parties. Verdict has to be given within a particular period. Suppose in case a sanction is to be obtained, the sanction has to be obtained within a particular period. Otherwise, if not decided whether this is a fit case to accord sanction or not, if no decision has been taken by the publisher, by the officer concerned, then there is a deemed provision, and the court can presume the sanction has been accorded. So in every stage of the criminal trial, from the very registration of the FIR till conclusion of the trial, that is till verdict has been given, there are timelines that has been given in support of the victimology. When case is to be withdrawn, if the state is of the view to withdraw the prosecution case, the state can be permitted to withdraw the case only after hearing the victim. And to my view, the main change in the BNSS in support of the victimology is assistant session judge. Now the assistant session judge is not sessions court. Learned judicial magistrate first class, judicial magistrate of the second class, chief judicial magistrate, assistant chief judicial magistrate, and the court of session, and additional sessions. Earlier in CRPC 1973, assistant sessions court was there. There is a confusion whether 307 case under section 307 or under section 304B IPC can be tried by the assistant sessions court. And in Tamil Nadu, quite long back, section 41A of Tamil Nadu Prohibition Act, 41 capital A of Tamil Nadu Prohibition Act, trial was conducted by the assistant session judge, that is the subordinate judge cadre. After the suo revision by the Honorable Madras High Court, there was a direction, since the punishment is life imprisonment, assistant session judge has no jurisdiction to take up the trial. And thereafter, before the Bombay High Court, Division Bench of Bombay High Court, there was a reference and the Honorable Division Bench of Bombay High Court in a reported judgment, 2012 Criminal Law Journal, 2012 Criminal Law Journal, page 4726. And Prabhakar, this is a case, Prabhakar L. Pawar versus State of Maharashtra. And yet another judgment by Patna High Court, reported in AIR 1957, Patna 375. AIR 1957, Patna 375. Kamaleshwar Singh versus Dharmesh Singh. So in these two judgments, the trial by Assistant Sessions Court was not approved. In Patna case, appeal was filed, appeal was received, and the notice was ordered that according to the Patna High Court, Assistant Session Judge is a subordinate to the Sessions Court. So it cannot be equal to the Assistant Sessions Court, so has no power to even to receive the appeal. And as per the decision made in 2012 Criminal Law Journal, page 4726 by Division Bench of Bombay High Court, making over the Sessions case to Assistant Sessions Court was stopped. In case of 304 IPC, minimum sentence of 7 years. If case is made over to Assistant Sessions Court, there may not be proper justice to the victim, because the very minimum sentence is only 7 years. If the learned judge wants to record a conviction and sentence more than 7 years, for the life sentence, Assistant Session Judge cannot impose life sentence. If after going through the evidence, if it is a case of before the learned magistrate, if learned magistrate wants to record more sentence, this can be placed before the CJM, there are provisions. But if case is conducted by Assistant Sessions Court, if the learned judge, after going through the evidence, want to record more sentence, it cannot be placed before the Additional Sessions or Principal Sessions Court. Now the confusions, there is a full stop. No such court is available after the BNSS 2023. To my view, this is a welcoming provision supporting the theory of victimology. Very recently, Kerala High Court was pleased to set aside the capital punishment. This is a case, State of Kerala versus Girish Kumar. Case was registered in the year 2015. Case was registered, taken up as SC number 353 of 2015. The judgment was rendered by the Additional Session Judge Kerala, Kollam Session Judge number 4, by judgment dated 5/7/2018. Capital punishment was recorded. The appeal was decided on 3rd July 2024. The judgment is very much available in live law. By this judgment, the sentence was set aside, accused was acquitted, and compensation was ordered. Taking note of the seriousness, I want to read few lines. This we conclude by taking note of the unique factual circumstances in the appellant's case, whereby he has been acquitted after finding him not only innocent of all charges leveled against him, but also holding that there was no reason whatsoever to even array him as an accused in the first place. So this is the accused was a victim. He is a victim at the hands of the public servant. We have also taken note of the fact that the ignominy of over 10 years incarceration suffered by him was compounded by the trauma of living through the said period with the ever-present threat of death sentence, which made life even more miserable and despairing to the appellant. Accordingly, we deem it fit to direct the state government to pay to the appellant an amount of 5 lakhs towards the compensation on the above count. which amount shall be paid to him within a period of 3 months from the date of the judgment. So this is not only the provision and judgment. And very recently, capital punishment was confirmed by the Honorable Supreme Court by the death reference number 180 of 2020. 180 of 2020. Taking note of the fact that by the Jharkhand High Court, State of Jharkhand versus Rahul Kumar, Criminal Appeal, Division Bench number 180 of 2020. So the victim has to be not only compensated, we know that justice not only be done, it must also appear to be done. It must also appear to be done. So with this aim, the 3 enactments have been brought forth. Very recently, Rajasthan High Court was pleased to quash a trial, taking note that the case is pending for more than 25 years. And in 2024, Live Law Rajasthan 123, Deepak Korwal versus State of Rajasthan, sentence was suspended, who served a sentence of 10 years. Across the country, there are number of cases pending trial, pending committal, pending registration of the case even, and a number of appeals has not been decided after even quite long years. I have cited Rajasthan High Court has granted suspension of sentence after 10 years. After 10 years. So, in BNSS 2023, even further investigation that has been approved and has to be completed within 90 days. Suicide, report on suicide, as per section 194 subclass 2 BNSS, the report on suicide has to be forwarded within 24 hours to the district magistrate. And for the first time, in every investigation as per 193 of BNSS shall be conducted without unnecessary delay. Prosecution documents has to be given forthwith to the accused. Complete committal within 90 days as per 232. So in every stage, the BNSS has taken care of victim and victim-centric approach for the first time in our country. So we have to welcome BNSS 2023. Victim of rape has to be examined immediately. Statement has to be forwarded immediately. No doubt, when we take reports from the National Crime Record Bureau, the offences against child, offences against women have been increased alarmingly. So this is the high time to protect the interest of victim. So victim-centric approach is the need of the hour. Taking note of all the things, BNSS 2023 has been coined. There are a number of provisions, taking note of many judgments and speedy trial. My friend may ask, sir, there should not be any urgent or immediate trial. It will also affect. No doubt. BNSS does not speak about. Case has to be furnished, the document has to be furnished within few days. There are elastic. There are some provisions giving some extra time to furnish the copies to the accused. and in all the stages. So to my view, the rights of the victim for the first time has been protected by BNSS 2023 in serving summons. Many lawyers who are appearing in the criminal trial know very well. In many cases, witnesses are not produced. More particularly, investigation officers. We take a list. In many cases, investigation officer has not been produced on the first occurrence or first date appointed for the examination of investigating officer. They took many time. Now, the summons can be served digitally. They cannot say he is not available. Now the summons can be served digitally. They can proceed further. So hereafter, time-bound trial will be there. We can ensure time-bound trial will be there. Many cases have been acquitted. In many cases have been acquitted, taking note that the FIR has been forwarded to the court belated. Documents have been forwarded belated. And after quite long time, if 10 years time has been taken, the witness will come to the court and depose. And normally there may not be any evidence without any contradiction. So on that contradiction also, many cases ended in the acquittal. So after BNSS 2023 have been brought forth, definitely victim-centric approach will be there. The trial will be completed within a specified time. That itself is a victimology approach. So I welcome this. With this, I conclude. My friends, you may raise any questions.
As usual, you have shared your knowledge with such a deeper insights.
Thank you, Ji.
Let me check out. One has asked the judgment of Madurai bench, which you have asked. You have shared. Kindly share the citation.
Yes, I will share it. Yes. Why will Pillai case? I'll give the judgment. V. Koil Pillai versus State, 2015, Volume 2, Law Weekly Criminal, page 145. V. Koil Pillai versus State of Tamil Nadu by its secretary. 2015, Volume 2, Law Weekly Criminal, page number 145. And
the other judgments also you can share it on the WhatsApp.
Yes, I will share. P. Alagarsamy case, 1999, Volume 3, CTC, page 464. Current Tamil Nadu cases, 1999, Volume 3, CTC, page 464. P. Alagarsamy versus State of Tamil Nadu. And MJM Maulana case, MJM Maulana versus Inspector of Police, Armughaneri Police Station and others. 2006, Volume 1, MLJ Criminal, page 218. 2006, Volume 1, MLJ Criminal, page 218. Kovil Pillai case has been decided by the Honorable Mr. Justice S. Nagamuthu, Learned Senior Counsel practicing before the Honorable Supreme Court. And the MJM Maulana case was decided by Honorable Mr. Justice M. Chokkalingam. And P. Alagarsamy case was decided by the then Honorable Chief Justice of Jharkhand, Honorable Mr. Justice M. Karpaganayak. With this, I conclude. Thank you. Thank you once again.
Thank you. And those who are not subscribed to the channel
Thank
Beyond Law CLC, they can subscribe to that. The previous sessions taken by Mr. Karunanithi and all of the speakers, you can watch on that. And those who want to connect with us, they can contact on the mobile number shared on the previous invite, of including this one. So stay blessed and stay safe. And tomorrow the session is as we take on the path of understanding the serious Service Jurisprudence by Mr. P.S. Rajagopal, the Senior Counsel from Karnataka. Understanding Service Law, Chapter 9, Reservation, Concessions, and Affirmative Action. Thank you, everyone. Stay safe.